Chapter 27, Unlocking Intellectual Property Right in Healthcare Higher Education. M. Central. Abstract. Intellectual property right in healthcare higher education. Many people says it's an emerging field in medical education. I would rather say health professional educators have been kept under dark about this field for decades or so. Now to match the global economy and growth, lot of light has been through to this IPR to create important among the young India. This chapter will briefly tell about the need of IPR and our presence in the world in terms of innovation and invention. The chapter discussed the need for innovation ecosystem in healthcare higher education and how to start innovation ecosystem at institute level and department level. A brief description of different types of IP are available in India like copyright, patent, trademark, industrial design. Layout design and geographical indication has been focused in the section Roadmap to IPR. This IPR chapter unlocks the patent, copyright, industrial design, and trademark filing process with appropriate examples and illustrations. The important outcome of any IPR work is to do a technology transfer. This chapter will slightly touch up how to start the process of technology transfer, present ecosystem in India, and the need to promote the concept of startups among faculty and students. Key words: copyright, patent, trademark, industrial design, intellectual property, technology, innovation, invention, ecosystem. Assess need. Why intellectual property right? Global competitiveness has redefined business strategies worldwide, and the focus has certainly shifted to examining how our knowledge resources can reposition our stand in the world market. It means that process of wealth creation is changing from resource-based to knowledge-based, i.e., it now depends on brain power and our ability to create, to sell, to explain, and to solve problems. As a result, in future, wealth would out of our brains rather than the ground, and the goods and services being created by our brain power would be marketed in the global village. Now, a basic question that needs to be answered is how to protect this property of knowledge. Prior to this, we need to think that how knowledge could be converted into property. Knowledge being abstract, there are only two ways of turning knowledge into property. One way is secrecy, which is used to protect three types of information, namely trade secrets, know, how, and rituals. Another way is intellectual property laws, including copyright, patent, registered industrial design, and trademark legislation and conventions. Why intellectual property right matter? Reward for intellectual creation, monetary, professional, recognition, encouragement, and growth. Creativity is encouraged, industrial growth, recognition of protection. They ensure protection and recognition for unwritten and unrecorded cultural expressions. Why intellectual property right in health professional education? Intellectual property in healthcare will help us in developing indigenous product, which is the need of the hour in terms of raising medical bills and healthcare expenditures in the country. In today's scenario, 90% of our healthcare solutions like equipment, instruments, and even the guidelines are imported. Only in farm industry we are the biggest manufacturers for the world, but the formulations are imported. So intellectual property is the heart of our Indian health system, as it has to sustain the financing model of growth and development. Brief: what is intellectual property right? Who can file intellectual property right? How to kickstart innovations? Government support. Different types of IPR, patent, copyright, trademark, industrial design, geographical indicator, IPR in medicine and higher education, technology transfer and commercialization of IPR. Contextualize. Mr. Innovation has added a feather in his cap, Namely, he has successfully patented a device which has traveled and become popular in a distant location. Let us see what he has to say about his patent. Universal backresting device. It was an accidental invention which started in 2012 with a rectangular board used as a headrest for our public health dentistry outreach activities. In 2015, a FB comment low-cost dental chair for our Nigeria's outreach program made us file the UBRD patent in 2015. Today, UBRD is a granted and commercialized patent for public use. Recently, Department of Community Dentistry School of Dentistry, University of Iowa, USA has ordered UBRD for their outreach program. In a nutshell, the UBRD invention started in 2012 at a school outreach in Caracal. Today, it has reached United States of America. Describe what is intellectual property right. Intellectual property right is a term used for various legal entitlements which attach to certain types of information, ideas, or other intangibles in their expressed form. The holder of this legal entitlement is generally entitled to exercise various exclusive rights in relation to the subject matter of the intellectual property. The term intellectual property reflects the idea that this subject matter is the product of the mind or the intellect, and that intellectual property rights may be protected at law in the same way as any other form of property. Intellectual property laws vary from jurisdiction to jurisdiction, such that the acquisition, registration, or enforcement of IP rights must be pursued or obtained separately in each territory of interest. Intellectual property rights can be defined as the rights given to people over the creation of their minds. They usually give the creator an exclusive right over the use of his, her creations for a certain period of time too. Who can file intellectual property rights? Intellectual property is an intangible creation of the human mind, usually expressed or translated into a tangible form that is assigned certain rights of property. Examples of intellectual property include an author's copyright on a book or article, a distinctive logo design representing a soft drink company and its products, unique design elements of a website, or a patent on the process to manufacture chewing gum too. How to kickstart innovations? Innovations in healthcare are the need of the hour for the growth and development of the country. Innovations at healthcare can be made possible only by a very good health professional educator. To begin, innovations can start at your own workplace, whether in a classroom, clinics, preclinical labs, or department. We should create a good ecosystem where students can be given an environment for an innovative thinking. Innovation needs to be started in health professional education to make India a developed country and to create a profile for the country. We are a very young independent country, but all this 75 years we have been recognized by most of countries as a service-related country, whereas we depend on other countries for work, which need to be changed if at all we want our nation to be a developed country in a decade or so. Keeping this in mind, the government has started various schemes and policies like Start Up India, Stand Up India, Atmanirbhar har Bharat Abhiyan, Be Vocal on Local Products, Make for the World, Skill India, New Educational Policy 2020. The process. To start innovations, the health professional educator should focus on the following aspects like platform, inclusion, ecosystem, drivers, discourse. Platform. Change in mindset. Egotistic approach to win-win-win approach. Friendly and a team leader attitude. Inclusion. Ready to accept changes. Encourage stupid question in classroom, clinics. Be available to the students. Ecosystem. Provide autonomy and flexibility in the classroom, clinics. Simple encouraging words like good, nice, well done, try better, good idea, good. Question. Develop policies for a good innovation ecosystems. Drivers. Encourage multidisciplinary and collaborative approach. Accept the generational change. Discourse. Encourage debate, discussion among students. Identify best practices among students. The five-pronged focus will foster innovations by democratizing information, identifying and empowering domain experts, ensuring institutional autonomy, freedom, flexibility, accountability, and transparency, increasing faculty and students' participation at all levels, improving governance and planning. Different types of IPR. IPR, copyright, patents, industrial designs, layout designs, trademarks, GI register. One patent. What is a patent? Patent is an exclusive right granted by the authority to the applicant for a limited period in lieu of full disclosure of his/her invention. What is required for patent? Three statutory pillars of patentability. 1. Novelty. 2. Inventive step. 3. Industrial applicability. Invention must be relate to a process or product or both. Be new, involve an inventive step. Be capable of industrial application. Invention means a new product or process involving an inventive step and capable of industrial application. Invention must not be published in India or elsewhere, in prior public knowledge or prior public use within India. What is claimed must be different from what is already known. New means a feature of an invention that involves technical advance as compared to the existing knowledge, has economic significance, makes the invention not obvious to a person skilled in the art. Would a person with ordinary skills have thought of the alleged invention? If the answer is no, then the invention is non-obvious. Industrial application. Invention is capable of being made or used in any kind of industry. I have an invention what to do next. Publishing. Publish in newspapers, media, journals, magazines, websites, etc. You will get publicity if the published invention is interesting. If you file the patent application after publishing, you will not get patent right because the novelty of the invention is lost through publication. Patenting. You can first file the patent application in patent office. You can publish your invention after filing the patent application. The patent office will also publish your invention in their journal. Hence, you will get both publicity and monetary reward through patents. Patent application processing. Provisional patent. A provisional patent specification is basically a preliminary application which is filed before filing a usual patent. It explains the invention in a broad manner. It is the document which may be filed before a complete specification. It is called provisional since it is incomplete and a predecessor of a complete specification which comes later. Although it is not mandatory, it is highly recommended as it has a lot of benefits for the inventor. Patent with complete specification has to have the following details in the application. Title of the invention, field of invention, use of invention, prior art, aim of the invention, summary of the present invention, brief description of drawings, statement of invention, detailed description of invention, drawings and worked examples, claims, abstract, what are not inventions, invention against natural laws, discovery of scientific principle, abstract theory and new property, new use of a known substance, second medical use not permissible, substance obtained by mere mixture, method of agriculture or horticulture, mere arrangement or rearrangement of known devices, any process for medical human beings or animals surgical treatment to render them free cure from disease or to increase prophylactic diagnostic therapeutic outcomes. Through copyright. What is copyright? The legal right granted to an author, composer, playwright, publisher, or distributor to exclusive publication, production, sale, or distribution of a literary, musical, dramatic, or artistic work. What does it do? Gives authors or artists the legal right to exclude others from using their works. What is protected? Literary works, musical works, dramatic works, choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, architectural works. What is not protected? Ideas, concepts, or discoveries, titles, names, short phrases, and slogans. Works that are not fixed in a tangible form of expression such as improvised speech or dance. Works consisting entirely of information that is commonly available and contains no originality. Anything written or created by the government. What rights does the owner control? Rights to make copies of the work, distribute copies of the work, perform the work publicly, display the work publicly, make derivative works. How long does copyright protection last? For the life of the author plus 60 years if the applicant is individual, 95 years for corporations. Copyright application processing, online application, uploading of documents in the website, objection if any within 45 days, grant of copyright. 3. Industrial design. An industrial design relates to the appearance of an article, which results from features such as the lines or colors of the article or its ornamentation. Benefits of protection of industrial design. What kind of protection does an industrial design right offer? The owner of a registered industrial design has the right to prevent third parties from making, selling, or importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design when such acts are undertaken for commercial purposes. What kind of products can benefit from industrial design protection? Industrial designs are applied to a wide variety of products of industry and handicraft items, from packages and containers to furnishing and household goods, from lighting equipment to jewelry, and from electronic devices to textiles. Industrial designs may also be relevant to graphic symbols, graphical user interfaces, and logos. 4. Trademark. A trademark is a distinctive sign that identifies certain goods or services produced or provided by an individual or a company. What is a trademark? A trademark can be any word, phrase, symbol, design, or a combination of these things that identifies your goods or services. It's how customers recognize you in the marketplace and distinguish you from your competitors. The word trademark can refer to both trademarks and service marks. A trademark is used for goods while a service mark is used for services. A trademark identifies the source of your goods or services, provides legal protection for your brand, helps you guard against counterfeiting and fraud. A common misconception is that having a trademark means you legally own a particular word or phrase and can prevent others from using it. However, you don't have rights to the word or phrase in general, only to how that word or phrase is used with your specific goods or services. For example, let's say you use a logo as a trademark for your small woodworking business to identify and distinguish your goods or services from others in the woodworking field. This doesn't mean you can stop others from using a similar logo for non-woodworking related goods or services. Another common misconception believes that choosing a trademark that merely describes your goods or services is effective. Creative and unique trademarks are more effective and easier to protect. 5. Geographical indicator register. A geographical indication is a name or sign used on products which corresponds to a specific geographical location or origin. The use of a geographical indication as an indication of the product source acts as a certification that the product possesses certain qualities, is made according to traditional methods, or enjoys a good reputation due to its geographical origin. 6. Technology transfer and commercialization of IPR. Technology transfer, also called transfer of technology, is the process of transferring technology from the person or organization that owns or holds it to another person or organization. These transfers may occur between universities, businesses, governments, across geopolitical borders, both formally and informally, and both openly and secretly. Need for teaching and commercialization 15. The main objectives of technology commercializing include leveraging R&D outcome and intellectual assets, raise the accessibility of scientific outcome to broad range of consumers, development of new services and products ready for commercialization, and last but not the least, to intensify industrial competition. The transfer can originate either due to technology push or market pull. The international scope of technology commercialization may encompass developed nations, developing nations, and other countries with economy transition. Process of TT. Step 1, invention disclosure. Step 2, evaluation. Step 3, patent application. Step 4, assessment and marketing. Step 5, licensing of patents. Step 6, commercialization. Role and scope of healthcare startups in IP. A widening gap between the needs of care seekers and traditional healthcare services has emerged as a major challenge. It adds to the unaffordability and inaccessibility of healthcare. All the factors have collectively contributed towards the growing healthcare startup ecosystem with the innovative solutions. Summarize. This chapter has explained the need of intellectual property in higher education for growth and development of the country with following key points. Access the need of intellectual property right. Set the innovation ecosystem in the classroom, clinics, department, institute. Encourage stupid or nonsense questions in your field. Identify and explore the innovative idea which can develop into reality prototype. Identify different types of IPR and locate where the innovative idea falls in. Register, secure the innovation in appropriate IP agencies. Transfer the technology to market or to start a startup. Evaluate. Think of problem or difficulty you face in your day-to-day process in your own field which delays or complicates the end result. Think of a stupid, nonsense ideas or concept for the particular problems you face. Develop the idea into a statement. X. Development of mouth mask with carbon filters for pathological usage to reduce formalin inhalation. Development of orthodontic or table for multiple fracture management. Development of rating scale for indigenous population in management of pain. Search the statement using tools for searching and search strategy in the available database. Write or note minimum of 3 to 5 difference between the existing solution with your ideas, concepts. If there are significant difference, then start writing your idea into a story or process of implementation. Identifying the resources for prototype development or to implement your idea on a trial at your classroom, clinics. If it's functional, then proceed with IP registration. Road ahead. In the world of innovation, India has an old reputation. It remains a minnow when it comes to patents. If over 600,000 applications were filed in the US and more than twice that number in China in 2017, in India, there were only 46,600 and patent grants came to just over 12,000 in a country of 1.37 billion people. To make matters still more difficult is the fact that India has spent just 0.7% of its gross domestic product in 2016 to 17 on research and development. In contrast, Japan, the US, and China have spent 3.2%, 2.8%, and 2.1% respectively in the same time period. in a nondescript building on a narrow, congested lane in central Mumbai. The Office of the Controller General of Patents, Designs and Trademarks is bent on changing this. It wants to make filing patents cheaper and granting patents faster, which it hopes will result in more applications. The road ahead for patents is paved with research and funding. While Indian companies, including startups, universities, and research institutes, need to direct their attention towards generating more patents. If India has to emerge as a hub of inventiveness, it also calls for increased spending on research and development.